All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near. Give attention. You will be heard. God save these United States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is the Florida Bar versus Anderson. Counsel.
May it please the court, Chief Justice CANADY in this honorable court, my name is Carrie Lee and I'm here on behalf of the Florida Bar. The Bar has sought review based upon the referee's recommended discipline of a 3-year suspension followed by a 5-year period of probation. The Bar believes that based upon Ms. Anderson's gross negligence and systemic failure to safeguard her client's trust account funds, resulting in a shortage that exists today of over $120,000, as well as the case law and the standards, support that the only appropriate discipline in this case should be disbarment. Further, Ms. Anderson sat on a bar grievance committee both as a member and a chair of the committee and voluntarily attended the trust accounting workshop during the bar's audit period and was fully educated as to what's required under the rules of Chapter 5. And yet she still failed.
Is it correct that Ms. Anderson has attempted to pay the money back into the trust account, but they were frozen? Is that accurate?
Your Honor, she has made no effort to file a pleading with this court or with the referee to make that trust account whole. Further, she was notified prior to the bar filing the petition for emergency suspension that they intended to file an emergency suspension, thus freezing the account, and she still did not make any efforts to make that trust account whole.
Sorry, can I ask you a question? So
yes.
So it seems like the Alters case is a pretty significant precedent from your perspective, and it seems like the court's rationale was informed in large part by the notion that the attorney in that case, even after he knew that there were problems with the trust accounts, that he continued to do the same types of things and
Correct.
Didn't do anything to fix it. What does the record say about that issue with the respondent here?
The referee in this case found that because she made attempts to hire a CPA and recreate all the trust account ledgers was different from the Alters case. However, we would argue to this court that she did not make any of those steps until after the bar investigation occurred, and we would distinguish.
Is there any indication that she knew about the problems before the bar investigation?
We would argue that even if she didn't know, she should have known. She was responsible for that trust account. She was making.
But the question is,
yes.
Did she know? Not what the bar believed. The question is, did she know?
The referee found that she did not know. That he found that she was she was negligent. We would argue to this court that she was grossly negligent and that she was making multiple transfers from her trust account to her operating account to make payments for things such as American Express. And conveniently, also, it was during a period of time when her operating account balance was low and she didn't have sufficient funds in that operating account to meet those obligations. For instance, in the Fairwinds Credit Union account, she issued a wire from trust to her operating account. She issued the wire. She filled out the wire details and issued an $8,500 wire from her trust to her operating account and then used that to make rent. And but for those deposits from trust to operating, she didn't have sufficient funds in her operating account to make that rent payment.
How long has she been a lawyer?
She has been a lawyer since 2003. She did not have a trust account until 2013. But
I'm sorry,
again,
what happened in 2013?
she went out on her own and opened her own trust account.
What did she do before going out on her own practice?
I can't remember. She was with a firm that handled did not have any trust account responsibilities. However, she engaged in a practice of law such as homeowners association law, which requires detailed record keeping. And for instance, in the Stony Brook matter where there was a shortage of $37,000, the new attorney for Stony Brook represented that to this day, they're still not sure who owes what. There were instances where homeowners were claiming that they had made payments to Ms. Anderson and there was no record of it. Therefore, the homeowners association was in a position that they couldn't necessarily foreclose on houses and things of that nature because there was such poor record keeping by Ms. Anderson.
The bar doesn't dispute the findings of the
Correct.
referee, correct?
Correct.
So we take them as true at this point.
Correct.
And those findings include a finding specifically that this was a result not of any intention or willful conduct by the respondent, but instead the result of negligent conduct.
Correct.
Hasn't our case law seemed to draw a distinction between negligence and in management of trust accounts, especially where it isn't in the millions of dollars or resulting in any sort of fraud or significant harm to clients, versus intent to use the money for personal gain?
Yes, Your Honor. In the Valentine Miller, she conducted horrible record gross negligence, and this court found that even based
There isn't even a
upon-
finding of gross negligence here, though, is there?
No, we are arguing, however, based upon the Alters case, and actually,
Yeah, but that seems to make somewhat of a difference. In other words, again, the fact, intent is one of those things that is really, we invest in the finder of fact. The finder of fact hears all the evidence, reviews the documents, and then makes a finding regarding intent. And it goes somewhere from purposeful to willful, intentional to gross negligence to negligence. And here it seems that the least amount of culpability was found by the referee here. Is that fair?
correct.
Okay. So given that, how is this not like Brutus and that line of cases where we've clearly given suspensions for negligent conduct and management, but where it's not in the millions of dollars like in Alters, and where it's gone on for years and years and years with the knowledge of what's going on and continuing to do so? How does that distinguish those cases from the others where we've found just 1 year, 2 year, 3 year suspensions appropriate?
No problem, Your Honor. I would clarify. In Brutus, the court, Mr. Brutus, when he was aware of overdrafts, he replenished the funds, which we would argue is different in this case. Further, in Brutus, the court did not find any 4-8.4C violations, whereas in this case, the referee...
Wasn't Brutus pre-Alters?
Yes.
So the trial court here seemed to suggest I'm only finding it because Alters suggests that negligent conduct is dishonest, right? Isn't that what the referee said?
He also said that because she failed to report the $100,000 shortage in the Dubé matter, that was also a violation of 4-8.4C, and that she was not being honest.
The Dubé one seems really odd to me. So as I understand it, and again, correct me if I'm wrong on the facts, in that matter, there was a pre-signed check of some sort that shouldn't have been issued to I don't know if it's Mr. or Miss Dubé.
Mr.
Dubé.
Mm-hmm.
Mr. Dubé somehow got a hold of the check, deposited it, the error was found, and then a certified check was then issued by Mr. Dubé, which was deposited back into the trust account.
Yes.
Is that fair?
Ms. Anderson explained that she was expecting funds to come from Mr. Dubé. She pre-signed the check and hid it under her keyboard in her office, and then somehow Mr. Dubé came to her office, got into her office, stole that, somehow knew the check was underneath her keyboard, and proceeded to take it, negotiate it to the bank, and then at that point there was the shortage. She tried to stop payment on that account. However, there was a shortage of $100,000 over a period of 5 days in that account.
Right, so that's all we're talking about here.
Yes.
Okay.
But under the rules, she's still required to report a shortage.
Oh, there's no doubt there's a trust count violation. Again, but in trying to find that line between disbarment or 3-year suspension, which is pretty significant, trying to define that line, a 5-day, again, the referee credited, a 5-day sort of mistake seems to be very different than I'm taking this and I am using it to buy a fancy car or an airplane or
I understand.
host a fundraiser for somebody or something
I
like that.
understand.
I'm asking, do you see a difference between those two?
I mean, we don't. We believe that she should have reported it. If she had actually reported
Tell me the
it,
Florida bar doesn't see a difference between those two things?
I don't believe so.
Do you think our case law bears out a difference between those two things?
Probably not, Your Honor. I mean,
Not in terms of whether there's a violation, but in
Right.
terms of the appropriate sanction.
Yes, okay, I understand.
And I sorry.
And I think in the Dubé matter, that is probably the least offensive conduct that we've got in this case. I think the real issue is the 8 misuse of client funds that resulted in multiple shortages in which that funds were again being transferred to trust. She received a $32,000 settlement in a case. It got deposited into her operating account. She didn't even realize it and then spent almost all of it, but $100, and then caused a shortage on the trust account when she wrote that check to Ms. Folk.
I know we only have a couple seconds left before your rebuttal time, but I do want to address this. The referee made a very interesting comment here, in which is that I find that as a matter of appropriate punishment here, that 5 years wouldn't be appropriate, not because disbarment's not appropriate, but because disbarment would just result in someone being disbarred and then having to take the bar and reapply, as opposed to remedying the situation we have here, which is giving a significant suspension and making sure that when this person gets back in, that they are being correctly supervised with their trust account. That seems to me a very rational way to look at what appropriate punishment is, given the nature of specific conduct.
Your Honor, the bar believes that if this court follows that line of thinking, that it will be very easy for attorneys to put their head in the sand, to not monitor their trust account, and to then cause and use it as their own personal bank account. And we believe that this court needs to set an example for everyone else that disbarment is the only appropriate sanction. I understand that the referee felt that the most appropriate thing was her to be on probation and to be supervised. We believe that this court,
After 3 years of suspension,
yes,
as opposed to 5 years and then the ability to reapply.
correct.
All right, counsel, you are now in your
Yes.
rebuttal time. You can keep going, but you're using it up.
I'll reserve. Thank you, Your Honor.
Good morning, Your Honors. May it please the court, my name is Warren Lindsay. My client, Elizabeth Anderson, is sitting at counsel table with me. We are not contesting that there were violations of the trust rules at all. The only issue that we agree that the referee should be affirmed on is the matter of the discipline that the referee decided to impose, which is the 3-year suspension followed by the 5 years probation, which I think is appropriate. The court found 7 mitigating circumstances, including that she had no record. In answer to the question about the Judge Labarga you asked about, after she became a member of the Florida Bar, she worked as an associate in other firms, so she never had any knowledge of any kind of trust account or anything like that. The referee, I think, as Justice Luck pointed out, was very, very thorough. It was a 2-day trial. The court heard from 16 different witnesses, from 2 accountants. The referee was very conscientious in listening to the case law that was cited by Bar Counsel and by us. All of the cases that had been cited to the court in the briefs were very carefully considered by the referee, and in the referee's opinion, you can see how the court had distinguished it.
I'm sorry to interrupt you. Can I ask you, what's the status of the $100,000 shortfall?
That's right.
It wasn't obvious what that is and what
Yes,
what
that
the
was
plan is for fixing that.
It was kind of a strange situation, too, just like the Dubé situation. That was one where a check had been tendered in a real estate closing, but apparently was never cashed. But Ms. Anderson understands and she fully intends to repay that, and she understands that in order for her to be reinstated, that obligation, as well as any obligation, has to be completely satisfied. So she intends to pay that.
But she hasn't attempted to, she's taken no steps to rectify that shortage.
She has not paid any of that back up to this point, but she intends to pay it back, and she understands she has to pay it back. In some of the cases that were cited to the referee, there were cases where people were placed on suspension where they had not satisfied a restitution obligation, and the Leanna Martinez case, which was a case, Chief Justice, that was not it was a stipulation case where Ms. Martinez had was found in the stipulation. This is very recent. It was accepted by this court last year, where she was a lawyer who had substantially more practice time than Miss Anderson, and she was placed on 60 days of probation, or 60 days of suspension, followed by probation, in which she had to make restitution of substantial amounts over a 3-year period. So, yes, Your Honor, she has not paid it back, but she fully intends to and is committed to doing that.
She served on a bar grievance committee before this was discovered?
She did. She served on a bar grievance committee.
For how long?
I think it was a 3-year term, Your Honor.
So, and by serving on that grievance committee, you said that she was unaware of trust accounting procedures. How is that possible?
I think it's possible. There was no evidence presented. I know the bar counsel in her brief said that there was incidents where she may have had trust account issues before her when she was on the committee, but I do not believe there was anything in the record to substantiate that. There was no evidence presented.
We have lawyers throughout the state serving on grievance committees who are just clueless about trust accounting procedures?
I think that there are. I think that if you're, my opinion, Your Honor, is a practicing lawyer in small firms, I think that that is something that could be addressed better in terms of educating into the nuts and bolts of trust account practice. I think that many attorneys in small firms or solo practice think that they are complying with trust accounting rules, and they're not complying with it. In this case,
on just a very basic level, taking money from a trust account and paying your office rent with it, that's not something that would be simply understood as a violation of a trust account?
It would be if it was as the way the court stated it would be, but in her case, the referee found that she was not doing anything like one of the other justices says. She's not paying for trips to Las Vegas or anything. The referee found what the primary issues in the case were, that money that should have been in one account was put in the wrong account. It was a bucket thing. Different bills were double paid. So yes, she was paying regular, not out of the ordinary kind of expenses from her for her operating of her firm, but just regular expenses. But when she was doing it, she did not know that she was doing it from funds that were improperly deposited in the wrong account.
Was she receiving a salary out of her firm's account?
There was no evidence, and I don't actually know that never came up in the...
Just as a matter of operation, you don't know if she was getting paid a salary or not?
I don't know. I don't know if she was getting a salary, Your Honor, or if she was taking draws. I know that never came up. I don't know that. I don't think that's in...
You know what account they were coming from?
It would have been from her operating account. Would have been either a salary or her or draws. Different lawyers do it different ways, especially when they're sole practitioners like Miss Anderson was.
I mean, it seems like if you're taking draws or a salary from your firm's operating account and money's coming from that, and then you're taking money from a trust account and putting it in your operating account to pay rent, it's basically the same thing as taking money out of there to pay yourself. It's the same thing. It's coming out of the same account.
It is coming out of the same account, but I think that the issue was the mens rea, that she didn't know, and the referee found that she didn't know, and I think that
I know the referee found that. I find it hard to believe.
Well, I think that it's interesting, Your Honor, because there was evidence presented that the referee specifically found that she had CPAs all the time. The CPAs were not catching this. I have found that I think that there should be a movement in the Florida bar where accountants, CPAs are certified as being knowledgeable in Chapter 5 Florida bar things, because my experience in my 39 years of practice is that for many cases that CPAs that are very good, for whatever reason, don't know the individual requirements of Chapter 5. But she acknowledges that she made these mistakes.
The problems here are not technical problems. People get into trouble for technical deficiencies in the way they keep their trust account records, but these are just the very fundamental. I mean, these are the kind of things that, about, trust account money goes into the trust account. Operating account money is in the operating account. And so it just passes my understanding that anyone who had any concept of the most rudimentary concept of a trust account would not understand this. But let me go back to a specific matter that the Bar Council mentioned. It had to do with, I believe, a wire transfer.
Yes, from the Dubé case.
From a trust account to the operating account that was specifically authorized by the respondent here, and which Bar Council said was transferred in order to meet rent obligations and other operating obligations. Tell me about that. What does the record show about that?
I apologize, Your Honor. I don't remember what that particular circumstance that the court's referring to. Which
well, you heard? Didn't you hear?
I heard a few. I didn't know if it was the Dubé case where the.
It's the. I'll tell you what it is. It's the Fair Winds Trust Account transaction on February 23rd of 2017, where the respondent wired $8,500 from the Fair Winds Trust account to the firm's operating account, and then the next day issued a check from the operating account for office rent for about the same amount.
Yes, I believe in that situation, if I recall correctly, that she believed that the money that was being wired was legitimately owed attorney fees in that particular case. That's my memory of that situation. But we're Chief Justice, we are conceding, and she is humiliated. She is ashamed of her conduct. She is not in any way deflecting that she made these errors. We just believe that under the existing case law, and the court has held many times that the court won't second guess the referee if there is reasonable case law that supports the referee findings and that it fits within the standards of lawyer discipline. And in this case, all the cases that were cited by the Bar Council below, the Alters case and the Johnson case, all of those cases were much more aggravated, and also they all involved something more. Like the Alters case involved the millions of dollars of errors with the bookkeeper having done the improper things, but also it involved the Mr. Alters lying to another firm, the Christian Searches firm, in order to get more money. The Clint Johnson case was one that the court indicated in the opinion that it struggled with, but Mr. Johnson's conduct was much, much worse. Plus, Mr. Johnson, while he was on an emergency suspension, he violated the emergency suspension in numerous ways. And the other cases, there's more. So I think that before Your Honors, that the issue is not. The issue is discipline and whether or not the referee had considered these things, had watched the 16 witnesses, had considered all of the mitigating circumstances. In this case, she had no prior record. She, unlike Alters and some of the other cases, as soon as she discovered the errors, she immediately spent Herculean efforts in trying to correct the matter. She hired a CPA, spent enormous amount of time. She didn't run away from the problems at all.
What are we to make of our case law, which is from Brutus, which states, the court has long held that misuse of client funds, quote, is one of the most serious offenses a lawyer can commit. However, in imposing discipline for trust violations, this court's case law suggests a clear distinction between cases where the lawyer's conduct is deliberate or intentional and cases where the lawyer acts in a negligent or grossly negligent manner. Here, in the Brutus case, the stipulated facts indicate that Brutus did not intentionally misappropriate client use for his own personal use. How do we distinguish then between cases where the money is not used for personal use and it's not intentionally done versus cases where it is significantly for personal use and it's intentional?
Yes, Your Honor. And I thought that the way you had phrased it earlier during Bar Counsel's presentation about negligence, gross negligence, and kind of the different levels, I think that that's important because the mental state of a lawyer is one of the things. But I think that goes to the referee. The referee has to hear the evidence and make a determination of where it falls on the negligence, which the court found in this case, the referee found in this case, versus the gross negligence versus some lawyers it's just outright theft. So I just think it just based upon the individual facts of each individual case as found by the referee, and in this case over a 2-day trial, the referee found that these were unintentional, that they fell on the negligent side. I don't know if I answered the court's question, but I just think it's just an individualized analysis that a referee has to determine based upon that.
I think, going over here.
Okay. Yes, sir. Hey, Judge.
I think having practiced law in a bigger firm and then in a smaller firm, and I hear to talk about the CPA, it is not the CPA who's involved in the daily practice of law whom you're turning the money or checks over to. That person decides. Usually it's a bookkeeper.
Yes, sir.
I don't know how big her firm was, whether she could afford to have a bookkeeper handling the accounts and deciding which accounts to go into and which account you can withdraw from and that kind of thing. But that's really the point person that can lead a lawyer into trouble.
Yes, sir.
And I don't know if she had that here or she was handling the money herself. If a client comes into her office and I'm going to pay you, $10,000 retainer to represent me in this real estate transaction or divorce or whatever, who in her office would decide where that $10,000 go to, in which account it goes to, and so on? Did she have such a person?
Yes, sir. In the court, or in the referee, before the referee, it was primarily a paralegal that was kind of a combination, just as you said, she had one staff person. It was a combination paralegal, bookkeeper, receptionist that did all those things. She did some of it herself, and then they would send records to a CPA, but that was the nature of the way it was done in her firm.
Right, so it's the daily practice. That's where, and we have, of course, we have sanctioned lawyers in the past for not properly supervising the person who handles the money in the office.
Yes.
And that person will have some discretion to withdraw from trust account to big account to pay the phone bill or whatever without the lawyer knowing it. And that's, I don't know, that's what we're talking about here. But it seems to me there's a lot of negligence.
No, she was negligent. She acknowledges she was negligent. She acknowledges that even if you decide to use a paralegal or a bookkeeper, you're ultimately the captain of the ship and you're responsible if they make a mistake. It's something I think that it can be considered in evaluating the mindset of the lawyer, the mens rea that we've talked about, but she understands that it's her responsibility no matter who she allows to do it.
Okay, all your time is exhausted. So.
Thank you, Your Honor. Thank you.
Yeah, please, the court. Just to kind of respond a little bit, this court in Alter said that the attorney is the person in charge and bears the ultimate responsibility for what goes on in that trust account. She's responsible for knowing where the funds are coming from and where they were going.
Let me ask you this.
Yes.
Because when you were up before, there was some discussion about this. It seems like we're talking about the difference between a 3-year suspension and then or disbarment. And we seem to be dismissing a 3-year suspension as being nothing. It's a big deal to a lawyer. It's hard for a lawyer to recover from that, isn't it?
Yes, of course. And they have to petition to get back in, and that can take some additional time.
Will she have to take the bar exam again? If she's suspended for 3 years?
No. Mm-mm.
Okay.
Now, if she's out for longer than a 5-year period as part of the reinstatement, she would have to take the bar exam again.
Okay. So she's suspended for 3 years. She can't practice for 3 years.
Correct.
So I guess she'll have to work as a paralegal or something like that? That's like if she wants to stay in the law business?
Yes.
All right. So, I mean, it seems to me like that's not chicken feed. That's a big deal, isn't it?
Yes, it is, Your Honor, and we don't dispute that a 3-year is just as serious, but we believe because of her gross negligence and we have 8 instances where she misused client funds.
But where do you go from 3 years not being enough to all of a sudden wanting, the full package. I want a disbarment. I'm sort of having difficulty. This is the second case this week where, the bar has come in wanting a disbarment when the referee has asked for something in between. That's a sanction imposed by the referee. And so I'm having trouble understanding why this warrants a disbarment as opposed to what the referee recommended.
Your Honor, based upon our belief that the Alters case is precedent case law for us, that's why we sought disbarment.
Do you agree or disagree that the facts in Alters are very different than what transpired in this case?
We would agree that they are different, but we would believe that her gross negligence is similar to Mr. Alter's. We have a shortage of $120,000. We have a 3-year period of where she was misusing client funds. She failed to do those monthly reconciliations where she would have then caught these issues of where funds should have been going into her trust versus operating.
You do recognize, if I understand the record and the findings accurately, that your gross negligence argument's inconsistent with the findings that are made, and you don't challenge those findings.
No, we don't.
Okay.
So going forward, it seems like if we think about the possible range of variables that could be relevant, so this is a case now where you're accepting a negligence finding. You've acknowledged that there isn't any evidence in the record that misconduct persisted after the respondent knew about it. Going forward in future cases, what would be the lines that we and that people who are trying to govern themselves and the referees? I mean, how would they know sort of what is a disbarment case and what is a 3-year suspension case if two obviously very significant variables that could inform that you're now kind of taking off the table as being things that would justify a suspension?
I'm not sure of your question. I'm sorry.
Okay, so going forward, you would leave us with the law being that negligence alone can get you disbarred.
We believe gross negligence.
But you're not. But as Justice just pointed out, you're not challenging the finding. So we have to accept that it's negligence. We have to accept that there was no misconduct that persisted after the respondent learned of the problem. And so going forward, is it the amount of money? Is it the number of improper transactions? I mean, what are the variables that you would leave us with to guide referees and us in terms of when we would disbar someone and when we would merely suspend someone for a long period of time like this?
Your Honor, the past case law for 3-year suspension, most of those were isolated instances. In this, we have a pattern of over a 3-year period of multiple instances, multiple shortages. We still have a shortage of over $120,000. In the other 3-year cases, most of them, they were, immediately replenished the trust account. We also, in this case, have 2 instances of violation of 4-8.4C, which in those 3-year cases, those did not have those. So we would argue are what the distinguishing factors are.
Thanks, I appreciate it.
Thank you.
Okay, thank you. We thank you both for your arguments.
Thank you, Your Honor.